part of the reason we're hearing this trial from Kendall is because Uvalde County currently has a shortage of courtrooms. With that, Mr. McKeska, would you please begin the announcements?
Good morning, Judge. Drake McKeska, attorney for the department, and the department is announcing not ready for trial, Judge.
Christy Knapp, permanency supervisor with Belong.
Permanency specialist with Belong.
Richard Saldivar, attorney for Aaron Davila, Judge.
Jennifer Harris, attorney for Shannon Cannon. I'm ready.
Kathleen Savage, attorney for the children, Your Honor. I'm ready.
Sherry Dye, Your Honor, attorney for Elaine DeLeon. She is the intervening grandmother. I'm ready.
Jill Roden, Tri-County CASA.
Ms. DeLeon, could you unmute and announce your name, please?
Yes, Your Honor, Elaine DeLeon.
Thank you. Thank you. Department has announced not ready. Mr. McKeska, would you please go into the reason for that?
Yes, Judge. So as I was getting ready for this hearing this morning, I was going through the exhibits that Ms. Kyler Green had prepared, and I looked at the Court of Continuing Jurisdiction exhibits that were prepared, and I noticed that there are prior orders from Haskell County, from Real County, and then in the interim, I found out that there is a divorce proceeding out of Potter County, and I don't believe that any of those cases have been transferred or consolidated into this case. If we were to move forward with trial today, the order could be overturned on appeal for lack of jurisdiction because the courts of continuing jurisdiction have not been transferred to Uvalde County. So I am asking the court to at least grant the department's oral motion to transfer and consolidate those various cases, but we will be filing written motions as well. So those are in the record. That way this court can acquire continuing exclusive jurisdiction over the children and then proceed with the trial in this matter, which I understand both parents have executed voluntary relinquishments.
Any response?
No objection, Your Honor.
No objection.
No objection.
Okay. Well, then I think just to keep things clean, since there's no objection, I'll grant the not ready and then have you the department submit the motions with the orders to consolidate. And then, I mean, unless there's no objection to the department's motion, I don't know if anybody's seen these orders.
I have not, Your Honor, but I don't doubt that there are other orders.
Yeah, Judge, I believe there's other orders. My clients referenced them before, so I believe they're out there.
Ms. Dye?
Sorry, Your Honor, I had trouble unmuting. I've seen them previously. I have not seen them recently to recall exactly, but I don't recall seeing them anytime recently. I saw them in the last case, I believe.
Okay.
Your Honor, for efficiency's sake, though, I would not mind getting testimony on the record regarding the relinquishment so that we might be able to submit all this to you in writing as opposed to coming back to court.
Well, Mr. McKeska, what is your position on that? I know you didn't want to commence prior to getting those orders signed.
I didn't. This is one of those areas that we really want to be safe rather than sorry. And because it is a jurisdictional issue, I want to make sure that those orders are signed and entered in this record prior to commencing, because depending on what case you read in the case law, if that's not clearly done before that trial is commenced, then that is grounds for appeal, and I don't even want to risk it. And so I'd much rather the court sign and enter the orders, and then we come back after that's been done in order to get the testimony during the trial.
And I tend to agree with that. So having heard no objection, I'll grant the department's oral motion to consolidate, but I'm also going to have you or have the department, Mr. McKeska, just send out the orders to all the parties, give them the opportunity to respond. And if I don't get any responses or objections, once I receive the orders, I'll go ahead and sign those. We're going to reset for January the 4th 2024 at 11 a.m. January 4th, 2024 at 11 a.m.
And then we'll get those drafted and submitted, Judge, and I can attach the CCJs. I don't think I have copies of those orders. I just have the search from I can't remember if it's Vital Statistics where we do that search, but I have those reports, and then I also have a copy of the decree of divorce out of Potter County. I am going to do motions to transfer and consolidate all of the cases because I doubt that the prior orders were transferred and consolidated into the divorce proceeding because that was done pro se. So just out of abundance of caution, every order that I'm aware of, I'm going to be filing motions to transfer and consolidate on.
Okay, understood. All right, then that will be the order of the court to grant the department's not ready. So reset it for January the 4th, 2024 at 11 a.m. Grant the department's oral motion for consolidation, order the department to provide all of the orders to the parties. And if the court does not receive any objections prior to receiving the orders, I will sign those and we'll move forward. We've got a little less than a month to get that done. So I want to move quick.
Judge, I've already been in touch with the legal assistant. They'll be done this week.
Okay, very good. Well, thank you all for your time and your service. Hearing this case due to a shortage of courtrooms in Uvalde County from Kendall County. Is there any objection?
No objection, Judge.
No objection.
With that, Mr. McKeska, would you please begin the announcements?
Yes, Your Honor. Drake McKeska, attorney for the department. We're ready.
Rochelle Acevedo for the mother, Vanessa Ruiz. She's not present, not ready, Your Honor.
Kathleen Savage, attorney, and guardian ad litem for the child, Your Honor. I'm ready.
Hi, Judge Jennifer Vegas, permanency supervisor with Belong.
Thank you. Okay, Mr. McKeska, is Ms. Diaz your witness?
Yes, Judge. She's one of the witnesses.
Okay, I'm just going to have to make sure, Ms. Diaz, if you could figure out how to turn your microphone up on your end because you're real quiet on our end. Okay. When we were here November the 2nd, Ms. Acevedo announced not ready. She had had some contact with her client, Vanessa Ruiz, the mother. In this case, Ms. Ruiz had expressed to Ms. Acevedo that she wanted to be involved in this trial. So on November the 2nd, 2023, in open court, I ordered the trial to be reset to today, December 7th, 2023 at 10:30 a.m. And I stated on the record that I was doing so that the mother could have a meaningful opportunity to participate in trial. And I also stated on the record that no further resets would be given. It is 10:38 and Ms. Ruiz is not present. The court is not inclined to grant any further resets. So with that, do the parties waive opening?
Yes, Judge.
Yes, Your Honor.
Any other housekeeping issues we need to take up?
Judge, I do have several exhibits prepared. They are all certified copies of documents filed in the court's file. So I would like to pre-emit those just for the sake of time, and I'm happy to share my screen and go through them one by one. Petitioner's exhibit number 2 is a certified copy of the returned citation for the mother, Vanessa Ruiz, showing that she was personally served on January 24th of 2023. Again, is a certified copy. Petitioner's 3 is a certified copy of the certificate of paternity research for the child, Michael, that was filed on October 3rd of 2023. And again, as stated, it is a certified copy of the file copy. Petitioner's 4 is a copy of the temporary order following adversary in this case. And I'll just scroll down. Certification. Petitioner's 5 is a certified copy of the status hearing order from this case from March 14th, 2023. Petitioner 6 is a certified copy of the initial permanency hearing order before final order in this cause from June 1st of 2023. Petitioner 7 is a certified copy of the permanency hearing order before final order from August 3rd of 2023 in this cause. And then finally, Petitioner's 8 is a certified copy of the family plan of service for the mother, Vanessa Ruiz, that was filed in this cause. and the family plan was filed on June 27th, 2023. And then again, I'll scroll down to the to admit petitioners 1 through 8.
Any objection?
No objection.
Petitioners 1 through 8 are admitted.
And then, Judge, with that, I would like to call my first witness. And are you the permanency specialist that is assigned to Michael's case?
Correct.
And how long have you been the permanency specialist for Michael?
For approximately 3 months.
Okay. And when you received this case, did you review the case and its history?
Yes.
Okay. And did you review the family plan of service for Miss Vanessa Ruiz?
Yes.
Okay, so are you familiar with the reasons this case came into the Department of Family Protective Services?
Yes.
Okay, and you're familiar with the orders for Miss Ruiz throughout the course of this case?
Yes.
Okay. Ms. Diaz, can you please tell us why Michael came into the care of the Department of Family Protective Services?
Michael had tested positive. He was born premature, and he tested positive for amphetamines and methamphetamines.
Okay. And after he was removed, has he, or can you just give us an update on how he's doing since he's been in the care of the department?
Since he's been in the care of the department, he has been doing extremely well. His foster parents ensured that all of his medical needs are met. He is receiving multiple occupational therapy, physical therapy, speech therapy, to help him be able to catch up to the stage to where he needs to be at. And so far, he has been doing very well.
Okay. You said that he's had some medical issues since he's been in the care of the department?
Well, he was born with medical issues.
Okay. What sort of medical issues has Michael experienced in his life?
He has experienced issues with his gastric issues. He was born with congenital heart defect to where he needs to be checked. He also has he is legally blind, and he was for a period of time receiving also oxygen. But since a while back, he's already been taken off of the oxygen because he's been progressing extremely well.
Okay. And based off of those special medical needs, does Michael have frequent doctor's visits?
Yes.
Okay. And what sort of doctor's visits does Michael have as a result of these issues?
He is being seen by a ophthalmologist, cardiologist, a GI. He also needs to go get his audiology checked to ensure that everything is moving as it should. He also is being seen by an endocrinologist, and he is seen also by a neurologist, his regular doctor, his PCP, and he also is being seen by a developmental specialist to ensure that monitor his progress of where he is at.
Okay. And how frequently does Michael have to attend a doctor's appointment?
Pretty much it's like every other month. If he doesn't have one appointment, he has another appointment. So it's like every other month, I would say that he has to be seen by a specialist.
Okay. And how long has he been placed in his current placement?
Since he was released from the hospital.
Okay. And when was he released from the hospital?
I don't have the exact date here in front of me.
Okay. Do you have a general time frame of when he was released?
I would say like about a month after he was born.
Okay. And when was he born?
He was born on December 2022.
Okay. So it's fair to say then that he's been with the foster family for the 2023 calendar year then?
Yes.
Okay. And has the foster parents ensure that he's attended all of those visits?
Yes. They're on top of everything.
Okay. And are there any special therapies or anything that they need to do at home to ensure that Michael continues to progress developmentally?
Yes, the occupational therapist, the physical therapist, and the speech therapist, they all assist the family in how to engage with a child so that he continues to progress in all those three areas.
Okay. What is the current permanency goal for Michael?
It was for family reunification.
What is it currently?
Family reunification.
Okay. So we're at trial today. Do you think that it's possible to reunite Michael with his mother, Miss Ruiz?
No.
Okay. So it's not possible to reunify them today. What is the department's position regarding Michael's permanency?
Terminate parental rights and for him to be adopted.
Okay. So would you say then that the current permanency goal for Michael is adoption?
Yes, correct.
Okay. Is that adoption with his current placement, the Zorowskis?
Yes.
Okay. Is Ms. Ruiz aware of all of Michael's special needs?
Is who, I'm sorry?
Is Ms. Ruiz, Vanessa Ruiz, aware of all of Michael's special needs?
I have never met her since he has been on my caseload, so I would imagine that she is aware, but I have never spoken to her.
Okay. What efforts have you made to establish contact with Ms. Ruiz?
I have gone to her home. I have called to the last phone number that was on file. I was provided with the current phone number. I did reach out to her, left her voice messages. I also sent her text messages asking her to please call me. I also reached out to her criminal lawyer that she has, I believe, out of the San Antonio area. I did leave a voice message to them asking them to return my call. And I also sent that lawyer also a text message also asking them, to please reach out to me.
Okay. And have you received any sort of responses from those attempts?
No, none.
Okay. Let's talk about Ms. Ruiz a little bit more specifically. During the course of this case, was Ms. Ruiz ordered to complete specific services to address the reasons for removal?
Yes.
Okay, and what services was Ms. Ruiz ordered to complete?
Drug and alcohol classes for her to help her with her substance use, parental classes, an OSAR, and I believe that was all that was asked of her. I don't know exactly off the top of my head.
Okay, if I showed you a copy of her family plan of service, would that help refresh your memory?
Yes.
Okay. Okay. Can you see my screen, Ms.
Yes.
Diaz?
Yes, sir.
Okay. I'm going to show you a document that's been pre-marked as Petitioner's Exhibit number 8. And it's actually, sorry, not been pre-marked, it's already been admitted as Petitioner's Exhibit number 8. And that's the family plan of service for Miss Vanessa Ruiz. Do you recognize this document?
Yes.
So was part of her family plan then that she be able to meet Michael's basic needs?
Yes.
Okay, and provide proof of employment and the ability to meet those needs?
Yes.
Also that she provide appropriate housing?
Yes.
Okay. Was Ms. Ruiz also ordered to complete a parenting program?
Yes, sir.
Okay. And to provide a certificate of completion for that parenting program once it's been completed?
Yes, sir.
Okay. Was she also ordered to complete a drug and alcohol assessment to address substance abuse?
Yes, sir.
Okay, and also to complete random drug testing as requested by the department?
Yes, sir.
Was Ms. Ruiz also ordered to continue to address her own medical conditions dealing with heart complications?
Yes, sir.
Okay. Was she ordered to complete individual counseling with Dr. Yates?
Yes.
Okay. And then a psychological evaluation as well?
Yes, sir.
And then to maintain contact with the belong as well, is that correct?
Yes.
Okay, so let's go back through just one service at a time. Has Ms. Ruiz provided any documentation to you demonstrating her ability to provide for Michael's basic needs?
No, sir.
Okay, are you aware of whether or not Ms. Ruiz has appropriate housing for Michael?
No, I don't.
Okay. Has Ms. Ruiz successfully completed a parenting program?
No,
Okay. Did Ms. Ruiz provide a certificate of completion to you for a parenting program?
no,
Has Ms. Ruiz completed a substance abuse or drug and alcohol assessment in the course of this case?
no, sir.
Has Ms. Ruiz been asked to complete random drug testing throughout the course of this case?
Yes, initially, when the case was started, yes, she was asked to, she was aware of that. However, she has not been compliant with that.
Okay. Since you became the primary caseworker, have you reached out to her to send her for random drug testing?
Yes, I have reached out to her, but she has never answered to any of my calls, and the phone number that I had previously was not a working number.
Okay. Are you aware of Ms. Ruiz submitting to any of the drug tests that have been requested of her during the course of this case?
No,
Has Ms. Ruiz participated in individual counseling with Dr. Yates?
she participated on 2 sessions, and that was it.
Okay. Do you remember when Ms. Ruiz attended sessions with Dr. Yates?
I don't have the exact date, but I know I had reached out to Dr. Yates, and she had provided me that she had just attended two sessions, and that was it.
Okay. Did Ms. Ruiz ever complete the psychological evaluation that was ordered?
No,
Okay. Throughout the course of this case, has Ms. Ruiz participated in her services to the level to demonstrate the ability to address the reasons for removal in this case?
no, sir.
Okay. Did the department create a visitation schedule for Ms. Ruiz?
Yes.
Okay, and what was her visitation schedule?
The schedule was once a week for an hour, but the visits were stopped after mother had shown up what seemed to be on drugs, and they had to stop the visit because while she was carrying the child, she couldn't carry the child correctly, and so the worker that was monitoring the visit had to stop the visit.
Okay. How frequently was Ms. Ruiz able to visit with Michael?
She, I believe, had only one visit, and that was prior to me getting the case.
All right, but so what do you know what the visitation schedule was? Was she able to see Michael once a week for an hour, twice a month? Are you aware of what the schedule was?
It was, I believe, it was once a week, but she only had that one visit, and that was
Okay.
it.
And do you recall when she attended that visit?
No, sir.
Okay. Since you've been the permanency specialist assigned to this case, has Ms. Ruiz had any contact with Michael?
No, sir.
Has Ms. Ruiz provided or reached out to you inquiring as to how Michael is doing?
No, sir.
Has Ms. Ruiz provided any sort of birthday cards, birthday presents, Christmas presents, anything along those lines during the course of this case?
No, none.
So it's your testimony that Ms. Ruiz was able to have visits once a week throughout the course of this case, but she only visited one time.
Correct.
Okay. Do you believe that termination of Ms. Ruiz's rights to Michael are in Michael's best interest?
Yes, sir.
Okay, and why do you believe that's in Michael's best interest?
She has shown no involvement with the child or wanting to get to know the child or know what the progress is or lack of progress of the child. The family that he is with have taken very extremely good care of him, but she has never shown any interest. All efforts that the department has made efforts in, she has not responded at all. So that to me just shows lack of interest in the child.
Okay. Pass it, Mr. Judge.
Thank you, Judge. Ms. Diaz, you said you've only been on for about 3 months?
Yes, ma'am.
And when you received this case, which caseworker did you receive it from?
It was from Kelly Fetters.
Okay, and did you review all of Ms. Fetters' notes?
Yes, I did.
To your knowledge, because you indicated you haven't had any contact with mom?
No.
To your knowledge, when was the last contact the department had with mom?
That might have been initial. I don't have the exact date, but it might have been in the initial stages of the case.
So you're not confident when?
No, ma'am. I don't have the exact date.
I guess there was a period of time when Ms. Ruiz was in custody. Do you know if efforts were made to visit her while she was in custody?
Prior to me being the caseworker? Is that what you're asking?
Well, let me ask it this way. Do you know if Ms. Ruiz was still in custody when you received the case?
No, I did not.
Did you verify whether she was in custody?
No, I did not.
And in your review of the file, did anyone make efforts to visit her if and when she was in custody?
I don't know.
In review of your file, do you know if she mailed letters to the department?
If Ms. Reese or the previous caseworker?
If Ms. Ruiz mailed letters to the department?
Oh, I don't know.
Did you review the entire file?
Yes. To the best of my knowledge, yes.
Okay. And do you just not remember?
No, ma'am.
And I'm sorry, remind me when you got this case, please?
It was about 3 months ago.
Okay. And you indicated that you haven't had any contact with mom. Have you verified with any of the providers whether she's actually been attempting to complete any of these services?
I reached out to Dr. Yates, but other than that, there has been no other, she has not completed anything else. So that was the only one that she had communicated with.
Okay, I understand that, but did you verify with these providers that she wasn't, that during your tenure, that she was not working any of these services?
There is a system that we use to check these, and usually when they get assessed, we get an email to where an assessment has been completed, and we have not received anything.
Okay, so did you make any calls?
No.
Okay, and did you verify that these 2054s were current so that she would be able to do these?
No, ma'am.
Why not?
Let me interject really quick just because of time. It's 11:04. I want to make sure you all get as much time as you need. Is this a situation where we need to recess and come back? Or do you all believe that we could hear the 11 o'clock adversary and come back and finish around lunchtime? I don't know how much time you need, Ms. Acevedo.
Judge, I just need to go through everything that Mr. McKesko had went through.
So you probably need at least another 30 minutes or an hour.
Possibly, Judge. I mean, I hate to do that to the court, but I understand that you have an 11.
Yeah, well, I want to make sure you get all the time that you need. And I had already discussed commencing this and then recessing it if we needed to. So it's 11:05. Do you know what's going on that next hearing, Mr. McKesko? Is there an agreement?
Judge, it's my belief that there's an agreement. I just need to confirm that with the attorneys and parties.
Okay. Ms. Greenlee, when can we come back to finish this trial?
I've already set aside 11/4 or January 4th at 11:30, if that's workable for everybody. And I put in an hour.
Okay. Then I think just to make sure Ms. Acevedo is able to have an adequate amount of time to cross and cover everything that Mr. McKesko covered, I'm more comfortable recessing and coming back January the 4th, 2024 at 11:30 to resume and conclude this trial. Again, that's January 4th, 2024 at 11:30. And then maybe you can get your client here.
Yes, Judge, I'll continue those efforts.
Maybe that'll allow her the opportunity to participate. So all other orders will remain in effect. The court's ordering a recess at this time, and we will resume and conclude January 4th, 2024 at 11:30.
And Your Honor, if we could just advise the caseworker to review the file. I know she's newer on the case, but it seems that there's history that needs to be reviewed.
I agree. I do agree. Ms. Diaz, I know you're relatively new to the case. I would like for there to be more testimony elicited with answers as to the case history I know Ms. Fetters was on this and she'd be able to answer all that stuff. I know you're relatively new, but I do want you to review the file as much and as thoroughly as possible before our next setting, so that when Ms. Acevedo and or Ms. Savage are asking you questions regarding the case, you'll be able to, if not know that information, but look it up. Okay. All right. That'll be the order of the court. Thank you all for your time and your service. All parties are excused. And Ms. Hernandez, since we're recessing this, I don't need you for the next one. We're all free to go. Thank you so much.
Okay, I just have a question about the exhibits. Are they just going to stay with the court?
They'll be emailed to Ms. Greenwald. Any objections
Okay,
to the court
perfect.
hearing this case from Kendall County?
All right, thank you.
No
Thank you, ma'am.
No objection, Your Honor.
With that, Mr. McKeska, would you please begin the announcements?
Yes, Judge. Drake McKeska, attorney for the department.
Christina Bersiaga, Child Protective Investigations.
Christy Knapp, Permanency Supervisor, observing.
Deborah Fuller, attorney for the mother, Betsy Hernandez. Ms. Hernandez, could you please unmute and announce?
My name is Betsy Marie Hernandez.
Thank you.
Kathleen Savage, attorney for the alleged father, Mr. Torres. No contact, Your Honor, not ready.
Anna Swallow, attorney and guardian ad litem for the child, ready.
Lorna Gentryman, observing, permanent state specialist with Belong.
Thank you. We're here today for an adversary hearing. So Ms. Savage, I want to make sure I understand, you've had no contact with your client. Has he been served?
Let me check real fast, Judge.
I think as of last week, he had refused a waiver.
He has not been served. I looked it up this morning.
All right, then I'll grant Ms. Savage is not ready as to the father on any orders to him. But we'll proceed with Ms. Hernandez today. Mr. McKeska, you all have an agreement?
We do, Your Honor.
All right, you can go ahead and state the terms and conditions now, if you would, please.
Yes, Judge. The parties have agreed that the Department of Family and Protective Services will be named as the temporary managing conservator of the child, and Ms. Betsy Hernandez will be named as temporary possessory conservator of the child. We're asking the court to enter orders deferring child support and medical support. We're also asking the court to order the parties to attend a family group conference to develop a family plan of service that's narrowly tailored to address the reasons for removal in this case. We're asking that the mother be allowed to have visitation upon her release from incarceration, and once she has been, she's able to, through whatever program she's going to be engaged in, to have visitation with the child 1 time per week for an hour, supervised by the department or an approved supervisor. With regard to the alleged father, Judge, the only thing that the department's asking with regard to him is that once he's been served, there be an order for genetic testing to determine whether or not he's the biological father of the child.
Ms. Fuller, is that your understanding of the agreement?
The only thing that was left out, Your Honor, I'm asking that my client be allowed to see her daughter prior to going into treatment. She does have a bed at Senecor and Corpus Christi for her inpatient treatment. She's not sure exactly when she's going to be released, but I would like her to be able to see her child before she goes into treatment. And we do need to find out where the child is. She asked that the child be placed with her parents who have her other children, and we need to confirm that that's where the baby is.
Is that something you all talked about when you were conferring?
Yes.
It is, Judge. We were trying to determine when the child was placed in a shelter just after removal, but it was unclear whether or not the child's been moved with the maternal grandparents.
Who would know this?
Hopefully the department.
Ms. Knapp is raising her hand, Judge.
Go ahead, Ms. Knapp. Let me swear you in. State your name, please.
Christy Knapp.
You swear from the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
The grandmother is a licensed foster home, so we have submitted for placement with Belong. They will be reaching out to her so that placement can be conferred and set up. As soon as we have that set up, we will be moving the child immediately.
Where's the child now?
Currently at the same shelter she was out upon being placed with the department.
This is the maternal grandmother?
Yes.
Okay, Ms. Fuller, does that answer your question?
It answers my question, but I'm concerned that I asked for that to be done a while, probably 10 days ago, and this baby's in a shelter when there's a licensed foster home and her relatives and her siblings. And now we're still waiting to get some type of confirmation. That's concerning to me. I think the child needs to be moved right away. I don't know why 10 days later, we're still saying we're going to look into it.
I concur. I would request that she be placed with her family. I thought that was going to happen a while ago.
Your Honor, we had investigations has originally asked for the baby to be placed there, and Lutheran Social Services denied it, saying they were too full. I did put in for placement again, and we submitted it. And once again, through placement, we have to go through proper channels for that. Again, Lutheran Social Services denied it. They checked again for the third time. And just this morning, I did text Christina in investigations, since it hasn't come to me as a permanency yet, but they did come back and said yes, that they would take it. I don't know what the issue was. They're with Lutheran Social Services. So they came back. I just texted Christine when we were on and said that they would go ahead and make let Violet come into the home. I don't know what's going on with the home. I don't know what's going on with Lutheran Social Services. So I told him I had a few days, the first of next week or the week of the 18th, that I could go. I would have to make arrangements. Somebody has to be bilingual, or the case manager has to be bilingual. All the paperwork has to be in Spanish. If we can make arrangements to do that. And I haven't
move the child.
They live in Laredo and they're Spanish speaking only. That's their
Okay.
preferred language.
So we're talking about maybe wait until the 18th to move the child.
Well, I told them I could do it the 11th, 12th, or 13th, or the week of the 18th. And I would have to have a bilingual person there, and the paperwork has to be in Spanish.
Well, if you have a court order, if you have a court order that this child is to be moved immediately, you're going to have to present them with that order and let them know that this is going to happen, because this should have been already.
I haven't heard back from Lutheran today yet to hear what they are saying.
Okay. Ms. Fuller, other than that, is that your understanding of the agreement?
Yes, Your Honor.
Ms. Savage?
Yes, Your Honor.
And Ms. Swallow?
Yes, Judge.
And you said you concurred with Ms. Fuller?
Yes, Judge.
All right. Ms. Hernandez, I need you to unmute, please. Did you hear the terms and conditions of the agreement that was announced by Mr. McKeska?
Yes, Your Honor.
Is that the agreement that you made?
Yes, Your Honor.
Did you have the opportunity to discuss that with Ms. Fuller, your attorney?
Yes, I did.
Do you understand what's expected of you?
Yes, Your Honor.
Did you enter into the agreement voluntarily?
Yes.
Were you forced in any way or made any promises or inducements to get you to agree to it?
Not at all.
All right. Are you asking the court to adopt and approve the agreement today?
Yes, Your Honor.
All right. And Ms. Burciaga, is everything that was in your affidavit filed with this case, to your knowledge, still true and correct?
Your Honor, it wasn't Mrs. Burciaga. It was Ms. Samaripa. She's the one that did the removal.
Okay. Have you reviewed the affidavit, Ms. Burciaga?
Yes, I did. And to my knowledge, everything is correct and the same.
All right. So this is your case now, or are you just standing in?
I believe this is my case now. They've handed it over to me.
Okay. Do you believe that this agreement is in the best interest of this child?
Yes, Your Honor.
All right. Do you believe that the department made all reasonable efforts to avoid a removal in this case?
I do.
And do you believe that if this child was returned home at this point in time, it would be contrary to the health and welfare of the child?
Yes, I do.
All right. Court will adopt and approve the agreement of the parties. Name the Department of Family Protective Services as a temporary managing conservator. Name the mother as a temporary possessory conservator. Court will find there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal, and reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned home. Court will take judicial notice that Ms. Hernandez is currently incarcerated and will be going straight into an inpatient facility. So I'll maintain a finding of indigence for her and maintain Ms. Fuller's appointment in this case. Court does not have any information on Mr. Torres Jr., so at this time I will maintain his indigency status as well and allow Ms. Savage to remain his attorney until he is served so that we can get the DNA testing done once he's served. Court will defer child support and medical support at this time and order the parties to hold a family group conference. If there's some way to do it in person, I don't see how it's going to happen with mom being incarcerated. So there's other family members that want to appear in person, then we can do it in person. But if not, I'll permit the parties to do this one by Zoom. Hold that conference to create family plans of service that are narrowly tailored to address the concerns that brought the child, Violet, into the care of the department. I will order that once mom is released, she can have an hour of visitation per week supervised by the department. However, prior to going to her treatment facility, I'm going to order that mom have a visit with the child in person for 1 hour before she reports. I'm going to order that the child be placed with the grandparents immediately.
Thank you, Your
Honor. It's a licensed foster home. Ms. Knopp just testified that there's no concern with it. I don't know what's going on with Lutheran Social Services, but I'm not going to wait on them. This child needs to be placed with family, not in a shelter. So that needs to happen. Probably won't happen today because of the distance, but it needs to happen by 5 o'clock tomorrow.
Thank you, Your Honor.
You're welcome. That's the maternal grandmother. And that's 5 o'clock tomorrow, December 8th. Okay, we'll be back for a status hearing December 19th, 2023 at 9:30. That's December 19th, 2023 at 9:30. Ms. Hernandez, I wish you luck with your treatment. I want to make sure you understand the state of Texas gives parents with CPS cases $12 to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. If you cannot do so within that 1 year, your rights to your child are subject to restriction as they are now or termination. Do you know when you're going to be released to go to your facility?
No, sir. It's a 30-day program, but I am looking to extend it to be there longer than 30 days.
Okay. Well, take advantage of every day that you have and work with Miss Gentry-Mann and work with Miss Fuller, your attorney, and Miss Swallow as well, the ad litem for the child, and make sure that you get everything that you need done and take advantage of this year. Okay.
Yes, Your Honor. Thank you so much.
Your Honor,
inpatient is going to be the biggest thing you can do right now is getting clean and staying clean. Okay.
Yes, Your Honor.
Proud of you for taking that step. Miss Fuller.
I just received a text message from CASA saying that they do have a CASA office in Laredo that have Spanish-speaking individuals that could help with this placement. They just need to contact Stephanie Cash and she'll be able to provide that information. But this case should be transferred to Laredo, and I'm not sure. I'm hoping there's not too much of a delay in that. Obviously, the status is set pretty quickly, but the case should be transferred down to Laredo.
Okay, well, that'll be on the department and belong to get pleadings filed, motion to transfer and all that. I'll be ready to go with the hearing on the 19th, but if we don't need it, we don't need it. Okay, anything I failed to address?
No, you're
Okay, thank you all for your time and your service. Ms. Gentry-Mann, if you want to get with CASA, they can probably help out with that transfer of the child. That might help you. All right.
Sure will.
Excused, and I will see some of you tomorrow. Thank you all.
Thank you.